Welcome to the Deep Dive. Today, we're tackling a really complex but super important question. How does the legal system here in Victoria actually balance the rights and, well, the necessary care for people experiencing mental illness?
It's a tricky balance.
Definitely. We've got this collection of legal documents, appeal judgments, submissions to reviews, stuff about our Charter of Human Rights. And our mission really is to unpack how the system tries to juggle these things.
And I've spent some time digging into these sources to help us navigate it all.
Great. Okay, let's just jump right in. A big player here, obviously, is the Victorian Civil and Administrative Tribunal, VCCAT. He sort of popped onto the scene back in 1998 with some, well, pretty ambitious goals, yeah.
That's right. The idea was to simplify the whole tribunal system, make it easier for people to access justice,
Right.
encourage things like mediation, alternative dispute resolution, and just generally be more flexible than the old courts.
And has it lived up to that? Its role seems to have grown a lot since then.
Oh, definitely. The workload has shot up. And it's taken on completely new areas, too, like human rights cases, disability issues.
Which wasn't part of the original plan.
Not explicitly to this extent, no. It really shows how our thinking about justice and rights has, shifted over time.
Which I guess brings us to this One VCAT initiative. That sounds very much like an internal push for consistency.
Exactly that. One VCAT was really about trying to get a more unified approach across all its different parts, whether it's dealing with rental disputes or guardianship matters.
So things like standard procedures.
Standard procedures, yeah. Better professional development for the members making the decisions, and a more sort of joined-up long-term plan.
Oh, yeah.
The idea was to keep quality high as it got bigger and dealt with more complex stuff. But, the question always is, did it actually fix those inconsistencies people worried about? Something to keep in mind.
And legally, VCAT's in this interesting spot. It acts like a court for some things, but it doesn't have that Commonwealth judicial power like a federal court. What's the practical difference for someone going through it?
Well, think of it like this. VCAT is fundamentally a creature of Victorian state law. Its power comes from acts passed by the Victorian Parliament.
Okay.
Federal courts get their power from the Australian Constitution and deal with federal laws. So while VCAT does a lot of court-like things, hearing evidence, making binding decisions, its legal authority is state-based.
Gotcha. But a really key thing our sources stress is that VCAT must follow the Charter of Human Rights and Responsibilities Act 2006.
Oh, absolutely. That's non-negotiable.
Yeah.
As a public authority, VCAT is legally bound to act compatibly with the human rights in the Charter.
And not just act compatibly, but actually consider them.
Yes. Properly consider relevant human rights when making any decision. This shapes everything. Really, the process, the outcome, it's fundamental.
And what about people who turn up without a lawyer? There's this idea of giving them due assistance. What's that look like?
It means VCAT can't just sit back passively. They have a duty to actively help self-represented people understand the process, what's required.
So explaining jargon.
Or explaining things, maybe pointing out what evidence they might need, guiding them a bit on how to present their case. The aim is fairness, a level playing field, even without a lawyer.
Which must be hard to get right consistently.
It's definitely a challenge. How well it works in practice is always a question.
And the people making the decisions at VCAT, the members, it's not just any lawyer, right?
Yeah.
They need specific skills.
Yeah, definitely. Given the specialized areas VSAC covers, mental health, planning, whatever, members often need deep knowledge in that specific field.
Right.
Plus, they all need a core set of skills, things like running hearings fairly, mediation skills, clear decision writing.
And it seems VCAT looks outwards, too. These external consultations and research projects suggest they're trying to stay on top of things.
Exactly. It shows they're, trying to get feedback, see how they're doing, where they can improve, keep up with changes in law and society.
Okay, let's pivot to the Charter itself. The Charter of Human Rights and Responsibilities Act 2006. Our sources really hammer home its core ideas. Rights in a democracy, rule of law, dignity, equality, freedom. Sounds pretty foundational.
It absolutely is. It was a big statement by the Victorian government, a commitment to better protecting people's fundamental rights here.
And it sets out this framework for public authorities, which includes courts and tribunals when they're acting administratively.
That's right. It tells them how they need to operate.
So it's not just nice words. It has actual bite. Public bodies have to act compatibly and consider rights. How does that work for, say, a council making a planning decision?
Well, if that decision might impact someone's right, maybe their right to privacy because of overlooking or freedom of expression if it's about signage,
Hmm.
the council has to actively think, okay, how does this decision stack up against those charter rights? They need to weigh their rights along with all the other planning rules, and their decision has to be justifiable from a human rights perspective.
Unless there's a lawful reason to limit the right.
Precisely. We'll get to the limitations part, but yes, the starting point is considering and acting compatibly with the rights.
And then there's Section 32(1), the interpreted principle.
Mm.
That sounds powerful, saying legislation should be read as much as possible in a way that fits with human rights.
It's a really significant legal tool. It instructs anyone interpreting Victorian law judges, tribunal members, to prefer a meaning that upholds human rights, if that meaning is open and consistent with the law's purpose.
And they can look elsewhere for guidance.
Yes, they're explicitly allowed to consider international human rights law and judgments from other places when they're doing this interpretation.
But are these rights absolute? You mentioned limitations. Our sources point to Section 7 too.
Correct. Rights aren't absolute. The Charter accepts that rights can sometimes be limited, but, and this is crucial, those limits have to be reasonable and demonstrably justified in a free and democratic society.
Demonstrably justified. What does that involve?
It involves a balancing act. You look at the right being limited, the importance of the purpose behind the limitation, whether the limit actually achieves that purpose, and critically, whether there's a less restrictive way to do it.
The proportionality idea.
Exactly. The limit shouldn't go further than necessary to achieve the objective. It needs to be proportionate.
And what if a law just can't be read in a way that fits with human rights? What can the Supreme Court do?
If the Supreme Court finds that a Victorian law simply can't be interpreted compatibly, it can issue a declaration of incompatibility.
Does that strike down the law?
No, it doesn't invalidate the law. That's key. Instead, it acts as a formal notification to Parliament.
Like a red flag.
Exactly. It signals, hey, Parliament, there's a problem here with human rights. The relevant minister then has to respond to Parliament, explaining how the government plans to address the issue. It creates a dialogue between the courts and Parliament.
And Parliament itself keeps an eye on the Charter. Considering adding rights or improving enforcement suggests it's not set in stone.
Definitely not. It's meant to be a living document. There are processes for reviewing it, seeing how it's working, and considering potential updates. That reflects that human rights aren't static.
And beyond the legal nuts and bolts, the Charter aims for broader things too, like making people feel more connected, improving public services.
Yes, absolutely. The idea is that if public administration respects human rights, it fosters a stronger sense of community, belonging, and trust in government. It's about building a culture of human rights.
Right. Okay, let's drill down into mental health laws specifically and how these rights interact. The Mental Health Act, it allows for compulsory treatment sometimes. Under what conditions and what are the safeguards?
Compulsory treatment is possible only if specific treatment criteria are met. Broadly, this means someone has a mental illness and they need immediate treatment to stop serious deterioration or prevent serious harm either to themselves or others.
But consent is the priority.
Absolutely. The Act puts huge emphasis on getting informed consent from people who have the capacity to give it. Compulsory treatment is really the exception.
And even then, there are checks.
Yes. There's a strict legal duty to consider if there are less restrictive ways to provide treatment and care, and crucially, the person's own views and preferences, including what they want from their recovery, have to be taken into account.
That less restrictive idea seems vital.
It's a cornerstone human rights safeguard in this area.
And the Act also has these mental health principles built in.
Yes, Section 11(1). They explicitly require respect for people's rights, dignity, and autonomy. They push for promoting recovery and full participation in the community.
And these aren't just suggestions?
No, they're legal requirements. All mental health service providers have to give proper consideration to these principles when providing services.
Let's unpack that no less restrictive way for the patient to be treated test a bit more. It sounds like a shift away from just doctor knows best.
It really is. It moves away from a purely paternalistic best interests approach. The decision maker must actively look at all the available options like community treatment versus inpatient care, and choose the one that imposes the fewest restrictions on the person's rights and freedom while still being effective treatment.
And the patient's view matters in that assessment.
Yes, their views and preferences, including their own recovery goals, are relevant factors when deciding what is the least restrictive option for them.
Our sources explicitly link this to charter rights too. The right not to have medical treatment without consent, freedom of movement, privacy.
Exactly. Those rights, like Section 10C on treatment consent, Section 12 on movement, Section 13A on privacy, they provide the human rights benchmark.
So any limitation under the Mental Health Act have to be justified against those rights.
Correct. Using that Section 7.2 limitations analysis we talked about, is the limit necessary? Is it proportionate? Are there less restrictive means? Regular reviews and appeal rights are also part of that safeguarding framework.
Capacity is another huge piece here. The idea that people are presumed to have capacity to make their own decisions.
A fundamental starting point. You don't just assume someone lacks capacity because they have a mental illness diagnosis.
And support should be given.
Yes. The law says you have to take all practicable steps to help someone make a decision first. Explain things clearly. Maybe involve family or support workers if the person agrees. Only if, despite all that help, they still can't make the decision, can you conclude they lack capacity.
But then you get these really tough cases, like in PBU and NJE v. Mental Health Tribunal, where someone's beliefs, perhaps delusional beliefs, mean they genuinely can't seem to use or weigh the treatment information.
That's the incredibly difficult edge. The court in PBU and NJE clarified this. It's not just about disagreeing with doctors or lacking insight.
Right.
Legal incapacity in this context means the person's mental illness affects their thinking so much that they're unable to understand the relevant information, retain it, use it, or weigh it up rationally to make a choice.
So it's about the process of reasoning itself being impaired.
Yes. Often linked to firmly held delusional beliefs that prevent them from engaging with the reality of their situation or the potential consequences of the decision. Like the example you mentioned earlier, believing you're immortal, so treatment risks are irrelevant.
That case, PBU and NJE, also mentioned personal identity and the dignity of recognition in relation to treatment decisions. That sounds really profound.
It is. Deciding about your own body and health is so deeply tied to who you are, your values, your sense of self.
Yeah.
Forcing treatment can feel like a violation of that core identity. Respecting a person's capable decision, even if you disagree with it, is about acknowledging their dignity and autonomy as a person.
Okay, let's shift slightly to equality. Section 8.3 of the Charter, equality before the law, equal protection without discrimination. Why is this especially highlighted for people with mental disabilities?
It's crucial because, frankly, this group has faced and still faces so much discrimination, stigma, and powerlessness within society and sometimes within the legal system itself.
So this right is about ensuring they get a fair go.
Exactly. It means they're entitled to the same rights, protection, and opportunities as everyone else without being treated unfairly because of their disability. In court, at work, finding housing, getting health care, everywhere.
And what does that mean practically in, say, a tribunal hearing? Does the system need to adapt?
Often, yes. It might require reasonable adjustments. Things like providing information in an easy-to-read format, allowing a support person to be there, maybe changing how questions are asked, or giving more time.
To level the playing field.
Precisely, to ensure they can actually participate effectively and have their voice properly heard.
Our sources also brought up habeas corpus, that ancient common law protection against being locked up unlawfully. How does that fit in with mental health?
Habeas corpus is fundamental to liberty. It's the legal mechanism to challenge the lawfulness of any detention.
So someone detained under the Mental Health Act could use it.
Potentially, yes. If they believe their detention isn't legally justified, or the correct procedures weren't followed, they could seek a writ of habeas corpus. The core principle is the presumption of liberty. The authorities detaining someone have to prove they have the legal right to do so.
And it's not just about being locked in a room. The Antunovich v. Dawson case seemed broader.
Yes, and Antunovich was interesting. She was on a community treatment order, but was told she had to stay overnight at a facility against her will.
Right.
The court considered if that direction, even without locked doors in the traditional sense, amounted to a restraint on her liberty sufficient to trigger habeas corpus scrutiny.
And did it?
The court suggested that a substantial restraint on freedom of movement, even if partial, could potentially qualify. It reinforced that any restriction on liberty, wherever it happens, needs clear legal authority.
Wow. Okay, so we've touched on a lot of specific cases that really illustrate these principles in action. You mentioned PBU and NJE on capacity.
And the no less restrictive test. Then there was CREC, looking at how the Mental Health Act limits rights and whether that's justified.
Marion's case, too, about dignity and rights for people with intellectual disabilities.
Yes. And Antunovich on habeas corpus and restraint. Collier v. Austin Health dealt with disability discrimination related to mental health recovery.
Masukandu. That was about fair hearings for self-represented people, especially those with disabilities.
Exactly. The duty on courts and tribunals. Then PJB v. Melbourne Health, or Patrick's case, explored freedom of movement, privacy, least restrictive means in guardianship contexts.
And the tribunal acting as a public authority under the Charter.
Right. And RIA-C looked at balancing community safety and liberty for someone under the Crimes Mental Impairment Act.
So a real spectrum of issues.
Absolutely. They collectively show this constant tension and balancing act. And that reference to NSW law about timely independent review of detention, it points to a broader push for stronger rights protections across the board.
So wrapping this up, our deep dive really shows, I think, a clear direction in Victorian law towards recognizing and trying to protect the human rights of people with mental illness.
Definitely. It's about finding that balance, ensuring necessary care and treatment, yes, but doing it in a way that respects fundamental rights like autonomy, liberty, equality.
And bodies like VCAT are right in the middle of that, guided by the Charter, trying to find fair, less restrictive paths.
Precisely. And what's striking is that it's not static. It's constantly evolving through new laws, court decisions, and just a growing understanding in society about the importance of these rights for everyone.
So thinking about all these complexities we've unpacked, how do you, our listeners, see this ongoing evolution playing out? How might it change individual experiences or how the community sees mental illness? And maybe what questions does this leave you with about where we draw that line between protection and personal freedom?
Lots to think about there.
Indeed. A huge thank you for joining us for this deep dive.